All right, we'll now begin our first panel of today, titled Harmful Interference, What It Is, and How Do Space Operators Avoid It? To moderate this morning's panel, we are pleased to have with us Colonel Sarah Mountin. Colonel Mountin is the Deputy Staff Judge Advocate at Space Operations Command West and the Combined Force Space Component Command, both located at Vandenberg Space Force Base, California. She previously served as the Chief of Space Law at U.S. Strategic Command and is a graduate of the McGill Air and Space LLM program. Over to you, Colonel Mountin.
Thank you very much. Welcome to our discussion today, and we're going to try to answer some questions for you. The two being, what is harmful interference? And then the second one being, and what do operators do to avoid it? Our panel is comprised of four well-known experts in the fields of space law and policy and in space operations. Something different about our panel that you'll see in versus prior panels is that we are mostly lawyers up here today, except for General Zellmann. Believe me, when you hear a little bit about him, as I describe him in a second, you'll understand that he is fully capable of being able to handle 3 or 4 lawyers on a panel. So with that, I'll go ahead and do introductions. General Zellmann is currently the Deputy Director of Operations for United States Space Command at Schriever Air Force Base in Colorado. As I mentioned, he's the only non-lawyer on the panel today, but not at a disadvantage at all. Prior to his joining the space operations side of military operations, he had a very interesting career path. Prior to his transition, he spent several years as an explosive ordnance disposal officer. That right there tells me he can handle anything coming at him. And then secondly, he was a physics professor at West Point. Next up, we have Mr. Andrew Duva, who is the president of Providence Access Company. Over the last 20 plus years, he has supported various international commercial satellite and telecommunication businesses on the regulatory, policy, legal, operational, and business fronts, with a present emphasis on government services, information assurance, and cybersecurity in support of national security missions. I tried to find some interesting things about him, but I did find out he's been very, very busy over the last 20 years in all of those areas. In the little free time that he does have, he likes to sail, and he is an avid motorcyclist. Next up, we have Professor David Koplow, a professor of law at Georgetown University Law Center. He's tuning into it and helping us today virtually. He joined Georgetown Law faculty in 1981, and he specializes in the area of public international law and national security law. He also served as special counsel for arms control to the General Counsel of the Department of Defense, as Deputy General Counsel for International Affairs at the Department of Defense, and an attorney advisor and special assistant to the director of the U.S. Arms Control and Disarmament Agency. We had a chance to talk a couple of times over the last few weeks, and what I understood about Professor Koplow, he's very, very excited about this topic, but not quite as excited as he is about becoming a grandpa again for the 3rd time. He has 3 beautiful granddaughters. And last but certainly not least is Dr. Michael Monero, currently the Vice President of Legal, Regulatory, and Government Affairs at Hawkeye 360 Incorporated, also appearing virtually. Dr. Monero is an attorney and public policy expert specializing in outer space with over 15 years of experience in government, academia, and in the private sector. Prior to his current position, he was the staff director and senior legal counsel to the House of Representatives, Science, Space, and Technology Space Subcommittee. He also served in the executive office of the president as a senior policy analyst and liaison to the National Space Council at the White House Office of Science and Technology Policy. Dr. Monero never passes up an opportunity to do a jam session. And from what I understand and what I found on the internet, he certainly can tell us a little bit about what it's like being an air and space lawyer and doing the best he can. That's actually a song that he actually wrote. Okay. To orient our audience on how this discussion we're going to play out, we're going to first hear from each of our panelists, and they're going to share their thoughts and perspectives on our topic today. Then we'll roll into a question and answer period. I will start with some questions, and then we'll certainly take some formal questions from our virtual audience as well as our live audience. And before we get started, as a reminder, the views and opinions expressed by the panelists are their own and do not represent an official position of the United States government or the Department of Defense. Our panelists will give opening comments in the following order. First, we'll hear from Brigadier General Zellmann. Next, Dr. Michael Monero. Third, we're going to hear from Mr. Duva. And then finally, Professor Koplow. General Zellmann, take it away.
So thank you. Thank you for that legal disclaimer. I always appreciate that going up front. I never know how much I appreciated those until today. You never know what you're going to say in public, and you're always hoping that you have a job again tomorrow after this goes live online somewhere. You know, I was thinking about what I was going to say here today, and I want to start off by saying thanks to a couple of folks, to Sarah for moderating the panel today. It's not an easy job, and she did a great job getting us together in advance, just so we kind of had a chance to meet and greet, so we're a little more comfortable when we're up here today. So I appreciate that. And then it's essentially all the folks that put this together. It's not an easy endeavor to try and put something like this together, bring folks in from all around the world and to run a world-class event. So thank you for that. And then I'd be remiss if I didn't say or acknowledge to the Air Force Academy and the legal department here. This is it's a world-class institution. It's a world-class facility. So thanks for hosting it. And thanks for getting a twofer out of this, so that a lot of folks that are in town for the Space Symposium could also take advantage of this legal conference. And you could hear and see some key leaders talk about it. You know, there's a difference for me being on the panel as the non-lawyer, but then I thought about it a little bit more closely and said, you know, well, I got a master's in physics, and there's Newton's laws, there's Kepler's laws, there's special law of relativity, and so all those laws are exact laws. I kind of like those kind of laws, but there is a new law that I've learned today, and the law is that never follow Professor Beard as an on panel, because everything that you were going to say, he's already said, and some of the things you're going to say are probably wrong. So I'm going to start with maybe addressing some of the topics here. So Sarah had mentioned we're going to try and define for you what harmful interference is and then how to avoid it. I'm going to burst your bubble a little bit. I don't think we're going to be able to define harmful interference today. My definition of harmful interference is going to be different than the Chinese definition of harmful interference. It's going to be different than the commercial owner-operator definition of harmful interference. But that's kind of the point, right? And so you got to ask, well, why are those terms used? And I think they're sufficiently vague on purpose. And I know you've had a number of speakers speak to you already today and yesterday about the tenets of responsible behavior in space. And if you look at those 5 tenets, they are sufficiently vague. They're staffed amongst a wide group of stakeholders. And so when you do staffing amongst a wide group of stakeholders, you come to the point where you have the common denominator. And common denominators are generally not very specific. And so there's a certain amount of ambiguity that's built in, and I think that's goodness. The second part of that is, and since these are tenets, we can't necessarily dictate what the behaviors are. We can only be exemplars of the behaviors in hopes that others will tend to follow them down the road. And so when we look at this Tenets of Responsible Behavior memo when it came out, and there's a nice little tasker in the bottom that tasked USSPACECOM to come up with specific subordinate behaviors, and I was the lucky recipient to that task within the J3. So for the past, I don't know, 6, 7, 8 months, we've been working a lot with OSD policy and a number of stakeholders within the Department of Defense to figure out what those specific behaviors should be. I'm not going to lay out what those are today because they're going to roll that out somewhere down the future, and I'm not allowed as a one-star to say that to you in public. So that will come out at a later time. But just to let you know, what we had to wrestle with a lot of those same types of questions when you get down to some of the specific second order level of detail of all the different stakeholders' interests. So even when you see the specific behaviors, you may not be satisfied there, and that's okay as well. And so I guess you could ask the question, well, why are we here today talking about harmful interference or vague tenets of responsible behavior or vague specific behaviors that fall underneath that? And I think the reason some of it was illuminated by Professor Beard, in that the State Department has looked at this problem for a long time and wrestled with the fact of legally binding agreements as being something that's probably not likely to happen in the space domain. And they looked at that for a couple of reasons. Professor Beard actually mentioned a couple of them. You know, it's very difficult from a space perspective to look at a platform and determine exactly what its use is because of the dual use nature of them. And then there's also the difficulty of trying to verify what that spacecraft is used for. And so I think we've gone away from the legally binding framework into something that's not legally binding. And so that's how you get into tenets and norms and things of that nature. And so that's kind of where we are today. And so, like I said, we can't really dictate from a DoD perspective what we think those behaviors should be, but we can sure enough be exemplars of those behaviors. And that's kind of what our role is going forward. To that end, you know, as soon as we got the tenets of responsible behavior from the Secretary of Defense, we took them and of course, what do we do? Well, we're an orders-based organization. We crafted up an order and sent it to our subordinate units and said, these are the responsible behavior tenets. This is the way we're supposed to conduct ourselves. If there are any issues that you have, please let us know now so we can figure out how we're going to go forward. And we'll continue to try and be those exemplars. And then the question is why is it important to those of us that are in here? And I've used this before with Josh during his promotion ceremony. I think there are two main professions that are sitting in here today, and I only think there are 4 total in the world. But 2 of them, the legal profession and the military profession, the profession of arms, are in here. So there's reasons why it's important for us to talk about the harmful interference today and how we get after them with these tenets and these specific behaviors underneath them. As we are operating in space, which is more contested, and our adversaries are putting more capabilities up there, it used to be okay just that we knew where things were. Now we need to know where they are. We need to know what they are. We need to know where they're going. We need to know how close they are to some of our things and what they could possibly hold at risk. And much in the same way that we've over time developed frameworks such as incidents at sea or conduct of unexpected encounters at sea from our Russian and Chinese naval counterparts, we need to eventually come to some type of a framework so we know what that expected set of behaviors is on orbit. So that when we see something that is unexpected, that's something that's unsafe or unprofessional, that we pay more attention to it. And that we can ignore the mundane and focus our resources on the things that are more hostile in appearance. And then eventually, hopefully, you get to the point where you're preventing that misunderstanding and that miscalculation that could lead to escalation. And so that's really kind of why it's important from a profession of arms perspective. The second part of the panel's question was supposed to answer how do we avoid this harmful interference? I don't think we should avoid it. I think we should embrace it. The example was used about Starlink, concerned about the Chinese being concerned about the Starlink proximity to the space station. That's an example of the Chinese being upset. They thought we were too close. In this case, we being a US commercial owner operator. You're never going to find out what's harmful until you start doing it and someone tells you that it's harmful. And you hope that you have thick skin and that they have transparency and you're willing to tell you that that's something that upsets them. Because over time, we'll figure out what that common denominator is for things that are harmful, and hopefully then we stop doing them. And so, like I said, I don't think we're going to avoid harmful interference.
Thank you, sir. Dr. Monero, will you please share some thoughts with us today?
Wonderful. First, thank you for the invitation, and I just want to applaud the Air Force and USSPACECOM for bringing this discussion into a public forum. I think it speaks volume of the insight that the leaders of this event have on the need to have discourse between the civil, military, and private sector community. So just a lot of kudos to your team. I want to start out by framing as a lawyer how I like to conceptualize the utility of the posited norms that exist in the Outer Space Treaty and more generally, so that as we have this discussion, you have a cognitive way of looking at this that maybe is more empowering than just looking at the words. And so the way I like to think about it is that law is a means to an end and not an end in and of itself. It's a normative function that increases legitimacy of a norm. So when you write something down and go in the international community and you sign a treaty, it raises the threshold of the legitimacy of it, and it increases sort of the reputational harm and the effects that happens when someone violates that norm. And when you look at the outer space treaties, the first treaty is actually called Agreement on Principles, and it's designed to be a normative document that sets principles that really help delineate what is and is not acceptable behavior. And going to the general's comment earlier, we may not be able to define what harmful interference is or how to avoid it, but I think if we look at the existing law, you can find tools in the toolkit that help us clarify what should and should not be considered legitimate or illegitimate behavior. So that's the first thing I wanted to share with you. The second thing is I wanted to share and follow up on the panel on due regard. So if you think about due regard as a fundamental principle of international law, and you look at something like the Chicago Convention, the Aviation Treaty, what you'll see is in the aviation domain, you delineate between a regulated civil aviation community and then state aircraft. And those state aircraft under the Chicago Convention are required to operate in due regard to the civilian operators. What's interesting in the Outer Space Treaty, crafted at a time of really precautionary principles, In Article 9, it starts off by saying, in the exploration and use of outer space, including the moon and other celestial bodies, states party to the treaty shall be guided by the principle of cooperation, mutual assistance, and shall conduct all of their activities, ... with due regard to the corresponding interest of all other states party to the treaty. So that's first thing you recognize is, oh, okay, unlike in aviation, right? They weren't able to have this ICAO regulatory authority for civilian operators. So they decided everyone is subject to due regard. And they link that responsibility of due regard through Article 6 of the Outer Space Treaty, where it links the state operators to the private operators licensed by the state. So you have that same fundamental principle. And then what's really interesting is Article 9 continues, and it creates both an obligation, a duty, as well as a right that sort of takes that principle and puts some skin and bones on it. And the first is an affirmative duty to consult when you, as an operator, have reason to believe that your activities are going to harmfully interfere potentially with someone else. And there's an inversion of that duty. There's a right to request consultation. And I think during our panel, and I think we should discuss this in the question and answer period, is what does that mean? And how can we build upon that? And how does that link to other posited norms in the treaty structure that we can take advantage of and clarify that right and that duty so that we end up in a place as an international community more empowered to be able to say to each other, that is or is not appropriate behavior. That is or is not something that should be considered harmful. So I'll stop there. I don't want to undermine the question period, but just wanted to share that framing with the folks in the room and online.
Thank you. Mr. Duva?
I would just like to echo the thanks to the conference organizers and to Sarah for all the prep work that she did in bringing us together. It's truly my pleasure and honor to be here amongst so many legal practitioners and other space experts. I'm going to bring more of a practical commercial view to inform you and maybe challenge and inform our thinking a little bit. Two questions: what is harmful interference, and what can operators do to avoid it? So, as has been stated, there are multiple definitions and understandings for harmful interference. In the traditional radio frequency sense, we actually have pretty good definitions in the ITU about what there are different levels of interference, right? There's that eventually rise to the level of harmful, and then there's the question of intentionality that is actually woven through this, but in the ITU is really not addressed. In other areas, such as physical interference, we don't know really what's harmful until there has been harm caused. So we could imagine a co-located orbital asset that comes up and collides with another satellite. There's been harm caused. But what if you're just nearby? Is it harmful if it maybe constrains your operations in some way? Maybe you're not exactly sure where you are. You're not free to maneuver. You think you should be free to maneuver, but you're causing risk. We don't know. And the treaty framework does not provide a good answer. So what has happened, notwithstanding Professor Beard's remarks, is that space actors have to fill in the vacuum, pun intended, with practical ways to address these questions. So norms, or really practices of behavior, have evolved. And so one thing I would mention is with regard to that physical closeness. Commercial owner operators about 11 years ago created something called the Space Data Association. I was privileged to be part of that. And what that is essentially a voluntary group of space actors, commercial, civil, indeed some military, contributing their ephemeris and planned maneuver information into a database. So unlike the US space track, which is looking backwards, right? This is what the catalog is, and propagate, you can propagate forward. This system actually incorporates people's intentions. and can then deconflict potential maneuvers. And the access rights to this system means that you have to agree by private law agreement to contribute that planned maneuver information. So you can't get the collision warnings the system provides unless you agree to also signal before you maneuver. So that's been fairly successful, but of course it's only a club of the willing. And you know, the club doesn't include all space actors and probably won't. But it shows that we can do practical things to try to prevent harmful interference in the sense of we're getting too close to each other, we're not coordinating maneuvers. On the more traditional sense of radio frequency interference, we have a whole very convoluted set of international, there's an international framework with the ITU, there's the Outer Space Treaty, there's the requirement that if you're a civil or commercial operator, you have to operate under the auspice of a state, and that state has to authorize and then supervise you. But the truth is, it is kind of the Wild West out there. Very few states have the actual technical capability to truly supervise what a commercial actor is doing. So what we find is commercial actors are going to do whatever they can, and so we see this with pushing the bounds of what is permissible or thought about. For example, we now have on-orbit servicing missions, something that probably we weren't thinking about too much 10 years ago. They're commercial, and it's commercial satellites and service vehicles going up next to and then doing zero proximity operations with a collaborating object. Well, what if it goes wrong, right? The flags of these different operators may not be the same, and it's the states that ultimately bear the liability, right, under the treaties. So what I wanted to really bring forward was that those commercial actors and civil actors in some cases are going to move at a much faster speed than the law is going to reflect. And in the practical sense, we're going to have to work within that ambiguity. And so really, I want to maybe disagree with Professor Beard a little bit about that norms are maybe as state-to-state instruments, they have a limited value, but in the practical world that we're living in, they have enormous value. And that's where the development of potential precepts for binding international agreements could occur. So I look forward to the Q&A about how we actually deal with interference in the practical sense, but thank you.
Thank you. Professor Koplow.
Thank you, Sarah. And I just want to say it's a great pleasure to be with you today to join this very interesting program. I only wish I could be there in person. In the time available to me, what I'd like to do is to offer the group a thesis, an argument that I hope you'll find provocative and interesting, even if you don't find it fully persuasive, because the argument that I want to put forward is the concept that when it comes to interference and to the rest of US space policy, my argument is that the long-standing US space policy is fundamentally unwise and illegal. And in particular, I'm focused upon the long-standing practice of the United States relying upon the private sector for the performance of a wide array of government space services, including communications, reconnaissance, launch services, and especially for the military and for the intelligence community. My argument is that that's fundamentally wrong. And I've recently published this argument in an article in a full-length law review article in the Harvard National Security Journal. And I encourage you to take a look at that for the full version. What I'll do today is just give you the précis of it. And that starts with the longstanding tradition, the longstanding cardinal principle of the law of armed conflict, that is the principle of distinction or discrimination that requires a separation, a differentiation between civilian privileged persons and objects and military objectives, and that in an armed conflict, a belligerent is allowed to target only the opposing military, not to directly target civilians or their objects. That's black letter law for the law of armed conflict. A lesser known corollary of that proposition, that's sometimes referred to as the requirement for undertaking passive precautions, but I don't like that term. I use the term reverse distinction. The requirement there is for separation, that the military is obligated to separate itself, to differentiate itself from civilians, so that civilians and their objects can be spared some of the worst ravages of war, and so that the opposing military can vindicate their legal obligations under the distinction principle to attack only military objectives, not to target civilians and their objects. And that principle of reverse distinction, the requirement for separation, is a long-standing part of the international law of armed conflict. It's reflected in the additional protocol 1, reflected in customary international law, binding even on countries that did not join that treaty. And it is hard law, but it's expressed in a remarkably soft way that it requires this separation only to the extent that it is feasible to do so. And feasible is one of those marvelously vague words that prohibits effective definition. It can take into account a wide variety of factors. There are plenty of circumstances under which it would not be feasible to separate military and civilian objects. For example, the entire US interstate highway system is used interchangeably by both military and civilian users, and it would obviously not be feasible to require the construction of an entirely separate parallel system of roads and bridges and tunnels to separate military and civilian users. And the same would be true of the national electricity grid or the local water system. Their feasibility would not be possible. But in many other instances, feasibility is available, and it is a legal requirement that we avoid placing military objectives in the midst of civilian areas. You can't put a military headquarters in a hospital. You can't put your anti-aircraft systems next to a school building. And in some ways, the most vivid illustration of this, one that animates my analysis, is a famous incident that many of you will recall. In 1991, during the first Gulf War, Saddam Hussein conspicuously parked 2 of his most advanced MiG fighters on the apron, the surrounding area, right next to an ancient archaeological site in Iraq, a famous temple that's 4,000 years old. And by placing them there, he either wanted to protect them so the coalition forces would not attack them, or to tempt the coalition forces into attacking those assets and then exploiting for propaganda value the damage that might inevitably be done to the priceless archaeological site. That was derided by the United States as a notorious example of a violation of the principle of reverse distinction, conspicuously avoiding the requirement for separating military and civilian objects. When it comes to outer space, however, it is now the United States that is the leading practitioner of the black art of avoiding reverse distinction. It has been the US policy sustained through the last several administrations, Republican and Democrat, to entangle military and civilian space objects. The conspicuous policy has been for the military and the intelligence community to use private commercial satellites as much as possible for military and intelligence community functions, including during times of armed conflict. And that deliberate insinuation of military and civilian assets together is, I argue, unwise and illegal because it violates the principles of reverse distinction. As I said, the obligation is not comprehensive. It is limited to what is feasible to accomplish. And so one question is, would it be feasible for the United States to not rely upon private commercial satellites, or for that matter, satellites from neutral and third states? Would it be feasible not to do that? And one would imagine that the argument is that the government can save a lot of money by using private sources for space monitoring, for Earth monitoring, for communications, for launch services, and that one can achieve a faster uptake in modern technology by relying upon the private sector. But my argument is that that does not mean that it's not feasible for the government to practice reverse distinction. Merely saving some money is not enough to prove that the alternative mechanism is unfeasible. And as evidence of that, we have the fact that the US government too is employing some of the same practices of the private sector. The government is moving toward a smaller, widely proliferated architecture of satellites to perform some of these same services on its own, doing so with lower cost, widely disseminated satellites, rather than the exclusive reliance upon the very large legacy institutions. Government's doing some of that same stuff. And the fact that it's a little cheaper to do it through the commercial site does not rescue us from the requirement to perform separation to the extent feasible. In fact, every once in a while, in unguarded moments, you hear US leaders acknowledging that part of the reason, not necessarily the main reason, but a big reason for reliance upon the private sector is precisely to complicate the job of enemy anti-satellite weapons targeters. That the purpose is to give the enemy so many targets that they could not possibly hope to take them all out, and they would therefore be deterred from attacking in the first place. That by proliferating through the use of the private sector, we would be having a deterrent effect upon the enemy. And that may be true, but it's just not legal. The purpose of the law of armed conflict is precisely to spare the civilians and their objects some of the worst forms of engagement in the armed conflict. The purpose of the law of armed conflict is to shift that risk from the civilians to the military, not to share that risk with the civilians, not to expose civilians to the danger of military operations to the extent feasible. The US policy has been exactly to avoid doing that. The US policy has been to rely upon the private sector for the performance of military functions for the purpose of complicating the task of military objectives. The effect of this, of course, is that the private sector satellites become military objectives. Because of their nature, purpose, location, or use, they are performing a military function. They are subject to targeting, and that expands the war. It carries the combat not only to government satellites and launch vehicles, but to the private sector as well. That is, I argue, unwise because it exposes to greater jeopardy the valuable services. It's also illegal. That the purpose of the law of armed conflict is to separate, and here we have deliberately avoided doing that. We've intermingled the functions, increasing the risk of interference and destruction upon the private sector. At least that's my argument. I'll be interested to see whether you have any reactions to that during the discussion period to follow.
Thank you very much. So I guess I have to apologize here to our audience. I promised you we were going to try this. We were going to give you this definition. We were going to answer these two questions. And I think that our panelists have showed you that it's a little bit more difficult to define harmful interference. So I guess my first question goes to you, Dr. Monero, and that is, how might we lay out a taxonomy of defining harmful interference to help our audience better understand how legal determinations are made? And then more importantly, is there anywhere in international law or public international law a definition of harmful interference or interference in general?
Thank you for the questions. Before I answer those, I just want to touch on 2 points Andrew made earlier. Great comments, Andrew. I just want to emphasize, I do believe innovation is a good thing, and that private space actors operating in space are in principle good for our national comprehensive power. And I know there's some complexities there when the private sector is moving faster than the regulator, but I do think it's in the US interest to facilitate investment and innovation from the private sector in space. The second thing is a complement to Andrew's point as well, which is, there's a process of crystallization of norms that happen in an international setting. It's a legitimizing process, and they result typically in the model of public international law as a posited international norm, posited written down treaty or something of this. I just want to make it clear that I do support the development of non-binding legal norms when appropriate. I think it's the natural evolution in public international law. And I think what's fascinating about the Outer Space Treaty regime is it flipped the normal evolution on its head. So the principles came before there was really sufficient practice to delineate specifics of the principles. And so what you've seen over the past 50 years are principles from the 60s and early 70s. And now you see activity happening and people starting to build normative frameworks, not all of them legally binding, to inform and articulate those principles in more detail, leading towards a normal end state of what would likely be at some point posited international rules. Now to your question, ma'am, first I just want to highlight that similar to Andrew's point, you can taxonomize harmful interference in a few ways. One of the ways I like to think about it is physical harmful interference, delineated from electromagnetic, radio frequency harmful interference, delineated from cyber. And I'm sure Andrew can say some things, particularly on the cyber front. I think what's interesting in the treaty regime is it really focuses on the physical. And then you have in the ITU various legal norms that focus on the electromagnetic. And so within the bounds of specifically physical, but potentially capturing all three of those within the taxonomy as a potential harmful interference, I do want to return to Article 9. So what's interesting is the obligation to consult when you as an actor believe that you will potentially cause harmful interference to another, and the corresponding right to demand that consultation. It's never really come to fruition very effectively because it's so ambiguous. It's in the mind of the respective parties. So I do want to turn the audience's attention to the registration convention, specifically Article 4, subsection 2. And no one talks about this, but I think it's really interesting that the drafters of these conventions put this in here. And what it says is that anyone who is a party to the registry convention has the right to provide the Secretary General of the United Nations with additional information concerning a space object carried on its registry. And what happens is when you take that principle that I can go to the international registry and provide any additional information I want, linked with the subjectivity of the right and the obligation to consult, you can actually start to remove the subjectivity. So if an operator goes to the registry and says, hey, I'm going to have my, moon resource activity here. These are the parameters of my activity. This is the energy level. This is the EM emission from the power plant. These are my corresponding telecommunication links. I physically will be moving around rovers approximately every 12 hours to go mine. Here's a map of the mining area. So if you did something like that and you put it into the international registry, all of a sudden, the party who has the right to request consultation and the party that has a duty to inform the other party of potential harmful interference has an evidence basis, so that the party can say, oh, look, I've looked at the registry. Maybe I should reach out to that person who's registered and have that consultation. And if they fail to do it, you might have legal recourse. Flip side is if you believe that someone might be causing you potentially harmful interference, you can also rely upon the registry convention. It's a very interesting way to put block and tackling around the ambiguity of what is harmful interference and to exercise that right and obligation in Article 9 in a more effective way.
Thank you. That leads me to my next question for Mr. Duva. What is the process or what is the reality of how owners and operators resolve harmful interference?
Well, that's a great question. First thing is we try to prevent it. And so the prevention piece is you receive your authorization for whatever your space object is. You're going to have to communicate with that object in some way. Even if it's not a communication satellite, it's going to have data links, it's going to have command and control links. Those are largely radio frequency links. We haven't gotten to the level of optical, which would be a different scenario. So that RF is managed under the ITU framework. And the ITU framework provides for essentially recordation and recognition of a performance envelope for systems that are coordinated. And that coordination process occurs between nations and administrations, actually. And so for a private sector operator, what they do is they go under whatever the flag is that authorized their space station, and they consult and coordinate the potential interference that they will cause into other stations or into ground stations, and they've reached something called an intrasystem coordination agreement. And you need to go through that process in order to get the recordation and therefore the protection from harmful interference from other parties. So those, if you're a commercial operator, those what we call coordination agreements, those are treated like any other highly important commercial agreement. You're going to operate within the bounds of what you've agreed, and the other party, if you perceive interference, the first thing you're going to do is try to figure out who it is, so you can try to geolocalize the interfering signal if it's from space or ground, and then you're going to look at those coordination agreements. Is the emission, is it inside that what's allowed, or is it outside? If it's outside what's allowed, is it due to equipment failure? Is it intentional? Is it just they didn't know? And so it's a very practical approach. And the first thing that happens before any of this, by the way, once that's detected, if you've gotten past the prevention of we're going to operate a certain way, is just restore the mission. That's what everybody wants to do. All this lawyering and the regulatory affairs stuff that I managed for decades at satellite companies, that happens later. The first thing that happens is let's get the service back. Then we'll go look at those agreements. We'll maybe talk to our national regulator, right, in the resolution. We might talk to other administrations. We might try to get our administration to avail itself of the dispute resolution processes at the ITU, at the Radio Regulations Board, and maybe get another registration essentially derecognized or a decision. But those dispute resolution processes are fairly rare. So the practice is on elimination of whatever is detected. And I just want to go back to something Mike said about cyber. RFI for commercial operators and EMI, that's every day, all day long, 24/7. Intentionality decisions later get looked at. Is it something warlike, or is there hostile intent? Then you go deal with your military or intelligence contacts and try to again practically work something out. But that's just a day in the day. And so it's gotten to the level. I went and did a survey before coming to the conference of many of pretty much all the global satellite operators, the general counsel level and the head of ops level. I asked them, what do they worry about? What they worry about is not harmful interference in the RFI, EMI scenario. They're on their risk registers for corporate in the top right is cyber. Cyber interference is what's keeping everybody up at night and during the day. And that's because we don't have these processes. We can't attribute the actor. If it's a state actor, we may or may not even be equipped to respond. And responding might be illegal. So that's where all the mind share is for the lawyers and indeed the ops folks. The radio frequency stuff is just de rigueur at this point.
Thank you.
Sarah, could I jump in here for just a moment?
Yes, sir.
I want to suggest that the effort to define interference in a meaningful way is ultimately a failed enterprise for two reasons. First, it's one of those terms that just cannot be defined. Lawyers are familiar with many words like this: reasonableness, due process, free speech. there are lots of terms that just cannot be reduced to a simple workable vocabulary. You could write a law review article, you could write a book, you could write an encyclopedia and still not exhaust the definitions of those terms. And I think interference is one of those where it's just too complicated a phenomenon to be able to state in a short, useful form. Second reason is that this treaty, or these treaties, were not drafted all that well. The Outer Space Treaty was the product of its time. It is a short, simple document. As Michael indicated, it's about principles. It's not about the details of operations. It does not define terms. And even in that key phrase in Article 9, it talks about not just interference, not just harmful interference, but potentially harmful interference. And as lawyers, you would strive for an interpretation that gave meaning to each word in that phrase, leading us to the puzzle of, if it talks about harmful interference, that suggests that there are some kinds of interference that's not harmful. And we're not prohibiting the interference that's not harmful. And the word potentially is, I think, misplaced. I think what they mean was you should consult about behaviors that potentially could cause harmful interference. But that's not what they said. What they said was if it would cause potentially harmful interference. And that phrase doesn't have much meaning in it either. So I think the effort to try to pin down what we mean by harmful interference, or interference in particular, I think is ultimately going to be frustrating.
May I respond to David's point, please? I agree with you in principle, David, but going back to my original comment, I don't believe law is an end in of itself. It's a means to an end. I think the real end here is people's behavior. And this is why I'm a proponent of exploring enhanced registration information, because I, as an operator, can say to the world, I believe that this is what I'm doing, and that if you start to do things of a certain type, you will affect my operations, right? So as the subjectivity of the person or the actor that wants to claim the right and obligation of consultation, or other rights and obligations we haven't explored yet under public international law, that's the only step I've thought of that is clear and actionable, that starts to shift people's behavior with an objective metric in the mind of the person or the actor conducting the activity. It's like putting the world on notice about something. And I don't disagree with you, but I also recognize that we, our generation and the generations to come, need to take those principles and work with them and find creative and evidence-based ways to legitimize and incentivize the behavior that we think is right for our community of practice.
Thank you. General Zellmann, my next question is for you. To what extent is our understanding of the operational environment sufficient to identify and interpret harmful interference and avoid it?
Yeah, so I was thinking about the last three comments here, and I like the way it was put, that harmful interference is kind of an interesting two-word combination. I look at it and say the word harmful is almost superfluous. If I have interference, that's generally bad. I can't think of a good interference. Going back to my physics days, there is a constructive interference that is good. But in general, I think I can't think of an operational perspective where I'd ever have a time when I have interference that's good. So from a profession of arms perspective, I look at this from a purposeful interference perspective as opposed to a harmful interference perspective. And that's really where the difficulty comes, because then you're trying to figure out, one, can you attribute to where the interference source is? And I think we're relatively decent at doing that. We don't have all the sensors that we would want to one, get at the timeliness, to get real-time attribution of where that interference source is coming from, if it's electromagnetic. From a proximity perspective, for on-orbit maneuver operations, we don't necessarily have the space domain awareness sensor coverage to provide real-time instantaneous notification that we have a proximity issues, that we're being interfered with. And so in that regard, there's somewhat of a time lag between when the interference happens and when we attribute it, or actually when we characterize it, and then when we attribute to who did it. And so that is probably not as good as it needs to be. But let me flip the coin a little bit to the other side. we operate a lot of equipment in space. And we are also not very good at, when we emit from an electromagnetic perspective, of understanding how much we're interfering with others, right? We don't monitor that at all. Somebody will tell us if we're interfering with them, and they do. And then we have to go back and figure out, well, are we the problem? And if we are, then how do we mitigate that problem and go forward, much in the same way that that was discussed here by Andrew to figure out how you mitigate those issues amongst owner operators. In this case, one of the owner operators is the U.S. government.
Thank you. Professor Koplow, question for you. You asserted earlier that the failure of states to separate military assets from civilian objects runs afoul of international law and law of armed conflict. However, is it really sustainable for states to separate their national and their military security assets from civilian space systems? And what would it take for this to really happen?
So this is another way of asking the feasibility question. That is, the obligation to separate is not a 100% requirement. There are plenty of circumstances under which it is just not feasible to do so. And then the question is, what's the rule in outer space? One example, I think, is hosted payloads. And that term gets used in a couple of different ways. One is more like rideshare, when there's a booster that carries into space a variety of satellites, some of which are used for military and intelligence community purposes, others are used for civilian purposes. Another is where there's a single bus that houses a multitude of components, some of which are performing military and IC functions, and some of which are performing civilian functions. And there are some advantages, economic advantages, to those cooperative mechanisms. It's cheaper, it's probably faster, it may be more efficient to share the load that way. But you're not supposed to do that. When there is a booster that carries multiple payloads, that entire booster and probably the launch facility becomes a legitimate military target during armed conflict. When there's a bus that houses both civilian and military payloads, that bus becomes a military objective, unless you're in the special circumstance where there's an adversary who has the very precise capability of targeting only the military components in a particular bus. And by modern cyber mechanisms especially, maybe there's some capability for doing that, but I'm not sure, and I'm not sure you could count on an adversary having that kind of very precise targeting knowledge as well as targeting capability. It would be feasible to not do that. It would be feasible to say military assets are going to go into space on a military booster. Military components are going to be carried on a military bus. And that would cost more, but it's not infeasible to do that. And by analogy, we see that other military services routinely do separate. The US Army does not say, well, we're going to rely on civilian trucks. The Army has its own trucks. The Navy sometimes might use civilian vessels for augmentation, but that's not the main plan. The main plan is that the Navy has its own fleet. It may cost more to maintain its own port facilities. There might have been some cost savings in merging those, but that's not the way the other services do it, and that's not what the law enables us to do.
Respond to a couple of things that David said. So the military may not have its, you said the Army has its own trucks, but the DoD doesn't build its own computers. The DoD uses the commercial Civil Reserve Air Fleet, where they essentially nationalize commercial assets and make them military assets. The Communications Act, at least for US authorized communication satellites, provides in times of conflict that those satellites can be essentially nationalized and therefore unambiguously confirmed as military targets, perhaps in your thesis as lawful ones. But the other thing, just to share, is that there are, for space actors, there are a number of space actors that work closely obviously with military and intelligence functions. I work with most of them, and I know most of the top executives at those companies. There's not a single executive at any one of those companies that does not fully understand that they are targets.
Maybe if I could add on to some of this. So it's a really interesting thesis put forward, and I applaud the effort because we really should think about how much of this entanglement we desire or don't desire. I think we all can make the argument that some of our most protected systems, those that do nuclear command and control, things like that, probably shouldn't be on a payload on an Intelsat bird. I think we'd all agree to that. But it's interesting. We have to figure out where that line is going to be, and so I'm going to approach it a little bit from a targeting perspective. I get the opportunity to sit on a lot of our targeting boards at SpaceCom, so I will try to keep this at the unclassified level. So we look at our various adversaries' targets, and we determine whether or not there's a dual use capability of those. And if there is, that's annotated, and we understand whether that makes it restricted or not. And so that assessment is made as part of our targeting process. When it comes to the discussion of the satellite payload and then getting down to the transponder level and then getting below that to the signal level, you start getting into some technology and some difficulties with doing precision targeting. And I'll use the same example that I've used with our intelligence community. If you target a satellite, that's like targeting a city. If you target a transponder, you're probably in a subdivision. If you target a multiplex signal, you're at a city block. And if you target the actual city, now you're kicking down a door. That's the level of precision you need to get to. And that's what we'd expect our adversaries to get to. And from a non-kinetic perspective, a lot of our adversaries do have the capability. So in terms of feasibility, I think it is feasible to put some of those signals on commercial satellites so that they can be used. And so that essentially as a taxpayer, we aren't paying for some infrastructure twice. But we've seen what's happened in Russia and Ukraine, right? As soon as you run out of precision munitions, you start going to the non-precision effects. And then as an owner operator, you're probably going to have to expect that you're going to have some collateral damage. And so all these discussions about, is there a reverse distinction issue? I think we need to have that discussion to see where we want to draw that line and where our owner operators are comfortable having that line drawn.
Thank you. Do our panel members have any desire to comment on anything else that we've discussed here, or would it now be okay to go ahead and turn it open to the audience, both virtual and in person, for some questions they may have?
I just wanted to address one point General made. It has to do with other parts of this conference. And so, sir, you mentioned how we rely on Keplerian orbit prediction and we don't have fidelity in sort of space domain awareness to know in real time, et cetera, et cetera. Now, of course, I concur with that. And I think what's interesting, number one, is that as the government builds out its space domain awareness capability and globally, that we have to really think, and this comes to Professor Koplow's point about potential use of sort of dual use technologies, right? And that it's going to be hard to crack that nut if we're just relying on government systems. And I think there's legitimate civilian and commercial applications for space domain awareness. And I think that needs to be part of the comprehensive solution. The flip side of that is this conference is discussing space traffic management. And a subset of that, goes back to this principle of due regard in the sense that in space, unlike in the aviation community, we don't delineate between state and non-state aircraft. So due regard is applicable to everything. And that's in part because the civilian aviation operators have the benefit of standards and recommended practices that sort of explain, like, you need to let us know where you're at, you need to navigate in a certain way safely. And so it's possible that as our community of space operators evolves, you might actually see a bifurcation, and you might see the state space objects, the state spacecraft, continue to operate in the more ambiguous regime of principles of due regard, et cetera, et cetera. And then you'll end up somewhere with the non-state spacecraft operating in a much more defined and rule-oriented area that removes some of the problems that the national security community therefore has, because now they can focus on the other state spacecraft that are operating under due regard, and delineating what is and is not acceptable for the civilian non-state spacecraft is a lot easier, and it's a lot easier to understand what is or is not going to be behavior or interference that's unacceptable.
Thank you.
Thank you all so much. Really appreciate all of the comments, the questions so far. Wonderful discussion. A couple questions have come in on the virtual feed. The first that I would like to start with is a question from Mr. Scott Bryson of Orbital Farm. And he's asked this question in a couple of panels now, and we just haven't had time to get to it, but I think it fits really neatly into this harmful interference discussion. He asks, what legal form or approach should an agreement take to limit attacks or sabotage on life support systems? So we've talked about harmful interference with respect to the electromagnetic spectrum, with respect to proximity. What about life support systems, and how could we address harmful interference with respect to crewed vessels and life support systems?
I think that's a great question. I'll just throw that out there. We haven't delineated between what's going to be acceptable and unacceptable when there's humans involved. And we've never really tested that theory. And I think it's much easier for the international community to affect the principle of due regard and affect the principles and duties and rights and obligations of consultation when it involves human beings on orbit. I also think Dr. Koplow, David Koplow's point is very astute as to being careful not to sort of put humans in a position on orbit where it's ambiguous of whether they're civilian or not. I think that's an interesting and almost a distinct line of legal logic and reasoning from just hardware on orbit.
I would just add that this dual use or multi-use platform complicates the question. Just to take one example, the Global Maritime Distress System, right, relies on geostationary satellites, which are commercial, also military, also intelligence, used for all three functions. Same satellites used for life safety. To take the general's approach, if you target that satellite, you're not just going to take down the military application, you're going to take down that life safety application for safety at sea. And I believe in the even in the Outer Space Treaty, there are at least words you could point to say that's too much. That's a little bit too far, even thinking back to the 60s. Over.
I'm not sure which way to go with this one because there's lots of implications, right? So I think we'd all agree that in a conflict, the power supply of a military facility is a legitimate target. But that power station could also then necessarily be powering the hospital down the street. So much in the same analogy here that you could have a safety of life SARSAT type thing that is providing coverage for search and rescue beacons on orbit. If you inadvertently target that, the collateral damage, I think, is the same type of ilk. I want to maybe go back a little bit and talk about the classifications of how we've gone steadily forward when it comes to space as a warfighting domain. We've for a long time had from ground to space, whether that's through jamming or we see some of the ASAT tests. Over the last couple of years, you've seen in the press, right, the space to space type engagements with our Russian and Chinese adversaries. We haven't seen a whole lot of space to ground, and so a space to ground. I mean, I guess you could consider the fractional orbital bombardment system that the Chinese launched this past year as being one. They could hold something on the ground at risk if they had it up there for a couple of revs. But we just haven't seen that come to fruition in mass at this point. Nor have we seen, and if I take the question literally, nor have I seen crewed spacecraft being used as combatants yet, right? And so it's hard to predict when or if that would happen. But that's something I think we have to consider now, so that down the road, when we do have a service called the U.S. Space Force, and down the road they may have folks that are on orbit that are considered combatants. And so then, is then a life support system targetable? I don't know. Is a scuba tank in the back of a Navy SEAL targetable? I think it is. And so it'll be interesting to have that discussion. I don't know where to land.
Good morning, Major DeFabo from U.S. Air Force. My question is along the jamming and the electronic magnetic spectrum interference In regards to how we sort of frame that, what could or could not be harmful interference, should we be framing this or thinking about it by the type of communication, such as, is it a TV station or some sort of other communication? Or should we be thinking about it less in that regard, about where the actual potential interference is coming, such on the uplink or the downlink? Thank you.
First stab at it. If you're a TV station owner operator and someone provides you interference, I think you're to consider it harmful. I'm not sure that's as useful. I haven't really considered it a whole lot in terms of, what type of mission that it's carrying is important or not in terms of determining whether it's harmful. I early on in my initial comments, I said, I think maybe it's on the eye of the beholder. So I think we have to take each owner operator's consideration for what they think harmful is. And what's I think important to understand here is when we talk harmful interference, we're still talking about peacetime. We're talking about the competition phase. We're not talking about crisis or conflict. As we get to crisis and conflict, and I had not read that Tenets of Responsible Behavior memo, even though I was charged with coming up with specific behaviors as closely as I should. But Professor Beard put a nice little caveat that said, unless otherwise directed. I'm a big fan of that statement now, because just like any other domain that's out there, we would not, I don't want to go down to Fort Carson and find an 11 Bravo infantryman and say, hey, your job in wartime is to shoot people. You want to go down to Colorado Springs to shoot someone today? It's not legal, right? It has to be sanctioned to do that, usually through rules of engagement and a named operation by the Secretary of Defense. And so when we get to actions that are harmful or beyond harmful, that are purposeful, the ROE will take care of that. Authorities delegation will take care of that problem. But on the harmful side, I think we're more on the how do we operate in the peaceful competition continuum? And I think all owner operators get a voice in that so that we understand what each other thinks is important.
In terms of the technical trend, at least on the RF side, what you're seeing is that everything's mixed together. Right, everything's moving to an IP stream or something. So it's to have the tools to be able to do that fine discrimination gets harder and harder in the RF world. And so maybe you're now into the cyber world of you're not going after that signal from the satellite, you're going after the satellite C2 or the ground station that affects it. So and I know that US planners think very carefully about these matters. I'm not so sure that all the potential adversaries really go down that fine-grained analysis, and they're going to probably use that broad, destructive. It's a satellite news gathering truck that's now it's a mobile jammer, right? And it takes out that city block or maybe even that part of the city. In the general's analogy.
We'll go ahead and take another question from online. There are two questions directed to Professor Koplow. First question, sir, is how do you apply your theory to critical infrastructure in the US? And the second is, are there enough military launch vehicles available today that it is practical to have military-only launches, as Dr. Koplow suggests?
Good. So the application to critical infrastructure in the US or to anything else is another dimension of feasibility. That is, for some critical infrastructure, maybe most, it would not be feasible to separate. You could not say that we should construct a duplicate electricity grid or to require that there be separate communications mechanisms across the country. But some of them you could, and some of them we do. Sometimes we do say, for example, that when you're building a new military facility, you shouldn't put it in downtown Manhattan. The general concept is that it would be feasible to separate the military installations from concentrations of civilians, and the same, I think, could be said of satellites. It would be possible to say, in fact, I think the direction that the United States is moving is to say, well, really, any satellite is a military objective, because any satellite could be used for military functions, even if it's principally used for civilian weather forecasting. Military applications are weather forecasting. No matter what you're doing, you could imagine that there could be a military feature, a military function for that satellite, and therefore the satellite, all satellites should be treated as military objectives. I think there's some grounds for that, but recognize where that takes us is obliterating the fundamental distinction, the fundamental law of armed conflict requirement for distinction. The concept is that you're supposed to separate, you're supposed to protect civilians and their objects and treat them differently from military and military objectives. And that's what we do in every other area. Yes, there are times when the Navy might use civilian ships, but not all the time. And we do not say all floating vessels are military targets. There are times when the Air Force might use civilian aircraft, but we do not say all aircraft are legitimate military targets. Our purpose, the law of armed conflict, tells us you're supposed to separate military from civilian. I think we could do the same thing with satellites. Right now, the United States may not have enough launch vehicles, enough dedicated military and intelligence community launch vehicles to carry out complete separation. That's an important limitation. Right now, it may not be feasible to rely exclusively upon military, but you spend more money and it becomes feasible. At some point, it's too much money and it's no longer feasible. But in the past, there have been times when that was what we did. And in the future, there could be times when that's what we do. The law of armed conflict requires us to separate.
Maybe I'm going to hit this a little bit from a deterrence perspective. And go through maybe a deterrence by denial, since we try to stay away from deterrence by punishment in space. To get to the launch vehicle question, right now we're reliant on several small number of launch facilities that we have to get all of our payloads, whether they're commercial or civil or government, on orbit. And that is somewhat of an Achilles heel, right? And one of the things that we've been pushing for a number of years is this operationally responsive space concept. Sitting at SPACECOM today, that we have a logistics officer, our J4, and you go to any other combatant command, and that logistics officer is responsible for all the functions of logistics: man, move, fix, fuel, arm. That's not what Jimmy Brown does for us. Jimmy has worked about trying to figure out what installation we're going to move to if we move, and how to get us enough desk chairs and seats and computers and things of that nature. Because the launch capability is service retained right now at the Space Force. In the future, I think you'd have to make the argument that if you're going to be an effective combatant command, you'd have to have that launch capability. To have that launch capability to do the logistics functions of resupplying, to refuel, possibly to rearm. And if you get to that point, then those missiles, those rockets, they have to be somewhat mobile and survivable. So they're not going to be operating out of those fixed facilities we have today. So in the future, you may get to the point where, out of military necessity for logistics, you create some of this mobile launch infrastructure that then relieves the dual nature that we're using the Cape and Vandenberg for today.
Morning, Major Zellmann, U.S. Air Force. We've had some discussion of cyber effects, and on 24 February, we actually saw a cyber effect delivered by threat actors against the KASAT network operated by Viasat, U.S. company, basically disabled access for tens of thousands of users across Europe. In your personal opinions, did this constitute harmful interference that would be prohibited by the Outer Space Treaty or the ITU Convention or other international law? And I would note open source, it's been attributed with some degree of confidence to Russian threat actors just at the open source level.
So I'll jump on that one first. So is it harmful interference? I think the owner operator Viasat would say yes, because they lost tens of thousands of receivers out of that deal, right? The more interesting question, and I'm going to pivot a little bit. So I got a couple of our operational lawyers back here. Mark and Josh are back there, and they work in our SPACECOM headquarters. And prior to the Ukraine-Russian scenario going down, I started asking them the questions. What happens if the Russians or the Ukrainians start doing electromagnetic interference on a US registered spacecraft, commercial? And the reason I asked that question is when you look at escalation and deterrence, there are certain rungs on that ladder that are going to be attacked first. Owner operators on the civilian side are going to be attacked before something that's DoD with a US flag on the side of it. I mean, I can imagine the Russians or Ukraine attacking a US WGS satellite first. They're going to go after Intelsat. They're going to go after Viasat. They're going to go after Eutelsat, just because the escalation bar is lower, the chances of them being attributed is lower, and so on. So I do think that, yeah, it's harmful interference. Is it an attack? I don't know. I'm turning that over to the lawyers. The advice I got at the time was, hey, it's purposeful. It's not necessarily an attack, and it's not an act of war is probably the better way of saying it, because we haven't risen to that level, because the intent, I think, of the adversaries, in this case, the belligerence, is between Russia and Ukraine. The fact that it happens to be in a US flagged bird, I mean, I don't think the intent was there to attack US flagship.
Just add, there was a French connection as well. Viasat got the press, but Eutelsat was operating some of the facility. So it's complicated. I can state unambiguously, but my personal opinion, okay. The operators involved did consider that harmful interference with their operations.
Ray Harrington with Air University. I want to ask a question about the relationship between due regard and harmful interference. So to start, I'm going to ask you to please suspend disbelief for a moment and assume that we're using Article 9 of the Outer Space Treaty. So we have an obligation to act with due regard, and we have an obligation to consult if we believe we might cause potentially harmful interference. So therefore, thinking that you might cause potentially harmful interference in itself is not a failure to act with due regard. It just triggers that requirement to consult or communicate with the other party in question. So assuming that consultations are held in good faith, but the harmful interference issue cannot be resolved, at what point would carrying out the activity and causing the harmful interference actually run afoul of the due regard principle, if at all? Thank you.
That is a fabulous question. I don't have an answer. I think that's the right question to ask. I do know this, which is the original issue that was brought to the working group in the early 60s that drafted that provision was Project Westford. So Project Westford was a dipole needle experiment that the United States Air Force did, testing, the ability to detect and do electromagnetic activity off the dipoles. And at the time, it's called COSPAR, I believe. It's an international community of scientific actors, astronomers. They kind of really concerned about it. And so the original impetus, public impetus for that language manifest from harmful interference within a scientific use. And the way that played out is, the United States completed its experiment and then didn't do it again, but it's not clear if it didn't do it again because they worried about the astronomers or they just found it wasn't very useful. So I don't have an answer to your question, but it's the right question to ask. And the treaties are not clear. And I think at the end of the day, if you cause harmful interference to another, it may or may not be in fact legal if you consulted on it.
I would add, from a RF perspective, what you've seen is the ITU and the whole process I described come into being. So that concept of coordination is actually the embodiment of due regard, if properly conducted. So, but that's not all classes of harmful interference by a long stretch. And if to take your question a little further, if you, notwithstanding coordination, continue to operate in a way that causes radio frequency interference, then wherever you are with Article 9, you have definitely violated the radio regulations, and they too are treaty obligations. So there is some recourse.
Let me just add, my perspective on this is that one of the ways in which that's such a good question is that it provides an opportunity to notice the sort of spectrum of international law responses to shared problems. On the one extreme, you've got the standard rules of international law, where every country can do whatever it wants to do, and it does not have to consider the interests of other states. That's the principle going back to the Lotus case from the Permanent Court of International Justice in 1927, saying that restrictions on the independence of states cannot be presumed as an attribute of sovereignty. Any country can do whatever it wants. It's not bound by any rules unless it is consented to them. Moving further down the spectrum, you get Article 9 of the Outer Space Treaty, which at least requires that you consider the interests of others, that you take that into account in making your national decisions, and that you consult them. That's short of requiring you to defer to the interests of other countries, but at least to take them into account. And then further on the spectrum, you'd have a system where you do have to defer to, or at least acknowledge, or at least negotiate with, and figure out some shared consensus way of approaching this problem, dividing up the resources. And space law has some of that too, as Andrew has just described. The Outer Space Treaty, I think, is in the middle in that regard, in moving us away from solo responsibility and complete autonomy of states, but not moving us so far as to actually require accommodation.
Yeah, and if I may hop on both David and Andrew's points, one of the things that I was thinking throughout this whole discussion was the insufficiency of only discussing the Outer Space Treaty. And this also goes the general's point, which is there's a whole toolkit of both positive and non-positive norms and other instruments that the government has, and its ability to affect costs, legitimize and delegitimize behavior and signal. And in this case, this comes full circle, which is what I was saying at the beginning, which is at the end of the day, it's about behavior. Right? So by requiring the consultation, you're trying to affect the legitimacy or the illegitimacy of what behavior will follow that. So if they consult and the consultations go south and the other party goes forward and causes or potentially causes harmful interference, there's a question of how the international community responds and what are the costs associated with that with politically or otherwise.
Thank you. Firstly, Dr. Mineiro, shout out to the dog. We all appreciated it in here. Certainly I did. My question sort of carries on from something that you said, Professor David, which is the radio regulations as a legal obligation does define both interference and harmful interference in that context. How helpful are those definitions in terms of our understanding of what it might mean under the Outer Space Treaty more broadly, in terms of endangering the function of a service, seriously degrading, obstruct, repeatedly interrupt, etc. How much do those concepts help us when we look at it in the context of the Outer Space Treaty more broadly? Thank you for all.
I think they're very helpful in the practical sense. As Mike said, the treaty really is a statement of principles. That's how it started, right? The radio regs actually have definitions, and those definitions are applied in the context of one set of technology. So they don't apply to other classes of interference. They don't apply to rendezvous and proxops, for example, which is an emerging area of interest and perhaps concern. So I think we can look at that as maybe they're just more colored in, and to David's point, they're just further along on that spectrum of implementation. So I think we can look to them as exemplars, but maybe we need other language that it has, that evolves and we can use in practice for some of those other technologies or other operational modes.
I think I would have a specific answer to this question by saying that those regulations are somewhat helpful. That is, they they are better than the blank slate that we're left with when we have only the text of Article 9 of the Outer Space Treaty. It is an attempt to throw one additional strand of law around this unruly beast of interference, and that's valuable, but it doesn't give us enough that would really solve the problem. And the part of the difficulty is that each of these little fragments of law is specific to its own particular context. And what we need instead is something that is more broad gauged.
Thank you very much. I just wanted to go ahead and sum up some of the things that we talked about, because I think we have provided some clarity. It might not be a satisfactory amount of clarity, but I think we've provided some clarity as to what is harmful interference. I think we've talked about it depends, which is a great lawyer answer. It depends. It depends upon the context you're in. It depends upon whether you're in a peaceful situation, in rising tensions, or in fully armed conflict, because that will definitely determine whether or not something is harmful interference. It depends upon, we're talking about radio frequency interference of the ITU. There is a tool there, there's a mechanism, whether operators choose to use it, at least is there, and at least in that form it is defined. Purposeful, is it unintentional or is it intentional? Are we talking about physical interference, observational interference, jamming, dazzling, permanent, temporary, irreversible, those sorts of things. The one thing that we didn't talk about is interference with national technical needs, treaty verification, intelligence gathering satellites. There's a specific treaty that actually prohibits interference with those sorts of systems. So again, not a totally satisfactory answer, but it does depend on the context. It does depend on the situation. And there are some tools out there to help give some clarity as to when something is harmful interference or not. As to how to avoid it, we've talked about communication is required between operators through data sharing, through some of the associations that are set forth, or just simply calling operators to explain what sort of behaviors they're engaging in space, so that other folks up there know what is in fact going on, so they can determine whether that might impact their operations. We talked about the need to promote responsible behaviors in space throughout the conference here today. And then finally, to Professor Koplow's position, we need to do a better job of separating our space systems under LOAC obligations. So thank you very much for all of your participation today. Thank you very much to our panelists, and over to you, Jeff.